slow panel in the sense that we go in the deep and that we take time to listen and exchange ideas, comments, and so on. CPDP was a fast conference in the beginning, 7 minutes presentation, bullet point wise, and I'm happy we blended that with other formats, and the book presentation is one. And I remember the one on Julie Cohen's book a couple of years ago, hosted by Joris van Hoboken. I was sitting in and I was enjoying. There needs to be a time to discuss books because I think they have proven to be the only sustainable medium for exchanging ideas with an impact. That's my. So the title of the conference of CPDP is plays toys with these ideas, with the concept of exchanging ideas, and I think nothing honors that concept better than a good discussion on a book-based discussion like the ones we're having here. And so the one we're having here is this one. It's written by Gianclaudio Malgieri, who works at Leiden University and still has a link with the Brussels University. Gianclaudio is well known for his a long series of activities and interventions and presence in an endless series of conferences and activities, which shows how what a span-width he had as an author and as a scholar. But he combines that with this faculty of sitting down and going deep. And I always wondered how those two could be combined. How can you be such a mobile scholar and at the same time find time to write a book like this? Is it a good book? Can it be a good book with such a life? That might be one of the underlying questions of today, but let's be elegant, let's not but so I'm going to pass the book around so you can touch it, and then you can get this itch to buy it, but please return, okay? Is that a promise? Just pass it around, and then the whole thing becomes more sensitive. So we did a conventional setup. We asked Gianclaudio to present this book, because I found in past book presentations, that's what me as an audience, for instance, the audience, really appreciate too, to hear the author setting out some main points about the content of the book. But then we asked, and Gianclaudio helped me asking 3 distinguished intellectuals to comment on this book, and also to share with us what the book and the idea behind the book does with them. Yeah? And I don't have to introduce on my right hand Wojciech Wiewiórowski, who is the EDPS, which is like the Tsar of data protection in Europe, but with a lot of unsari habits. And one of the good habits of my Polish colleague, who is also an academic, is his literacy. We all know Wojciech reads a lot, and watch out, he might have read your work too. So before you shake his hand, and that is a unique capacity. One wonders how that can be combined. So we have a lot of questions about. And then Julie Cohen, who opened up the conference on Friday and who was here several times before, is a very strong mind. And I'm very interested in hearing, in seeing these two minds meet today and assess each other's ideas, because that's what it's all about. So Julie Cohen is linked to Georgetown University and is the author of many books that are amongst the CDPR must-reads. And then from Amsterdam we have Natali Helberger. The reason Amsterdam is all over CPDP has to do with the individual top quality of all those people there. It's more than the city. It's the attractiveness of the scholars that works as a magnet. And Natali is definitely one of the persons that created that attractiveness of easy and so we're very happy to have you here, Natali, and we know that you I know your work not quite well. I know some of your work because it's very rich, and I'm happy to see you in a stage as a feedback and as a commentator in this panel. So that having been said, we have a little bit more than an hour, which is for me a wealthy amount of minutes, and I'm going to give 15 minutes to Gianclaudio.
Yeah, so thank you so much. I have no words to say how grateful I am for this panel, panelists, and for you being here. Friday morning, I know CPDP, it's a very hard time, as my voice reveals. And of course, there are many things on this table. A big invisible thing is my imposter syndrome coming. But it helps a lot to think that today is just an occasion to speak about the topic, not about a paper, not about a paper book, but about a topic. And that's why I think the first thing we put here is VULNERA logo. Many in this room are part of a VULNERA project. It's an observatory for vulnerabilities in data protection law. You can go on the website, it's open access, and it's the great help of many young researchers who helped to create a catalog of many of bibliography and case law on vulnerability. So, as I was saying, I feel, you know, to fight this this vulnerable position that I feel now, I want to say that this book actually has many moral co-authors. And at least the main moral co-authors are at this table. It seems like redundant. It seems silly to say, but actually it's like that, and I can explain you why. Going from Natali to Paul. Natali Helberger some years ago wrote a wonderful co-authored articles about consumer vulnerability. At the end, there was a call for extending the notion of consumer vulnerability to data protection and data subject vulnerability. That call was heard, and I tried to try to work on that call. So how, and this was my starting point, how vulnerability in consumer theories, vulnerable consumer, could be exported to data protection, which is a field that was a bit considered, that was a bit starting from consumer protection in Europe. Like the framework was that one in the 90s, but now it's much more, right? Now it's a fundamental right tool. And that shift was interesting to observe. And then going to Julie, I think there are many things that Julie's work, for which Julie Cohen's work was so important for this book. First of all, considering data protection in a power dynamics framework, because that was a bit the mission here. Yes, we can look at individuals, but there's an overarching picture to consider, and this is the power dynamics, but also the fallacy of notice and consent that Julie claimed very well during the years was very important to understand. Then what else? What are the other solutions? So turning data protection inside out, maybe through data vulnerability concept, one of the possible tools. And then Wojciech Wiewiórowski, well, for many reasons, he's a legal scholar, is a legal informatics scholar, and an institution, the EDPS was so relevant, and the EDPB also, their opinion, they were the one to try to open the notion of vulnerable data subject that is just in a recital of the GDPR. Basically, a book built on a recital. I know it's a bit crazy, but thanks to the EDPS opinion and the EDPB actual opinion on DPIA, there was this tension to say, well, vulnerable data subjects are especially children, but there are many more, including, and there were some examples made, workers compared to their employers, citizens complaining to public administration. And there are many more examples, but then there was a final clause saying, and then a situation of power imbalance. So that was a real call for theoretical action. And then, Paul De Hert. Paul was my mentor during all this journey, a provocative mentor. And I will also, during the presentation, there are many points. I mean, I will do this short presentation because, you know, I'm so grateful you're here, but I assume you don't know much about the book it's just published 1 month ago. So, and Paul was so relevant in several theoretical points that they had to adjust. And then I see in the audience many people that were also so relevant for this. So I see Jedrek, who was my co-author for the Vulnerable Data Subjects article in 2020. That was very where everything started. So how vulnerability theories in gender studies could inform the data protection discussion. And many more people that I cannot mention, including my colleagues at Leiden, students, and Lexo, where this discussion is very much. Carlotta, who helped a lot for the final steps in reviewing the book. And I cannot mention, but many more things. So just to go back, maybe explaining a bit where all this story began. I mean, I like this picture just explain this unsustainable dualism, because I think it's quite effective. And my students nod because they know this slide. So basically we tend to imagine this dualism when we talk about vulnerable people, right? We tend to imagine that there is an average data subject, usually under the perspective of the average consumer that we can have in our mind, a white, straight, male, middle-aged, without disabilities, etc. And on the other part, we imagine that a vulnerable data subject might be a person with a disability, a racialized minority, elderly, a child, etc. This dualism is unsustainable for many reasons, but I think we can open this insustainability with more examples. First of all, we don't have just the black and white. We don't have just the vulnerable and the non-vulnerable. This was a bit a seduction that consumer law was injecting, that we have the average and the vulnerable. It was a bit a 90s idea where you, for predictability reasons, you imagine that there is an average person that is quite rational, and then you have all the rest. But all the rest is very limited, right? It was very strange, but now there are more sensitivities on the table. We know that there is cognitive sciences that are telling us that we are all vulnerable in certain situations, but also studies on power dynamics, gender studies were so relevant in opening this concept. So actually, first of all, we should say that there are layers of vulnerability. It's not just white and black, but also this discussion about the spectrum is not enough. The spectrum doesn't exist alone. I think what we need to consider is contexts. So these two avatars, the privileged and the vulnerable, can act very different on the spectrum depending on the context. And again, here I'm playing with stereotypes. But let's consider the sexually suggestive online ads. For sexually suggestive online ads, probably what we call the privileged data subject is much more vulnerable to manipulation, because it might be younger and more exposed to sexually suggestive ads, attentiveness to and understanding of Instagram privacy policies. The young might fear this FOMO, this fear of missing out, and he or she might really need to consent. So I know it seems crazy, but maybe a privileged person in some situations is more vulnerable to give consent rather than another person that doesn't have that kind of interest. These are just examples to show the complexity of the topic. And there are many vulnerability theories that were informing this research. Beyond consumer vulnerability that I already mentioned a lot, I think one thing we should consider is the tension between particularism and universalism. So the particularism is coming mostly from bioethics. Yeah, I don't want spoilers. The particularism is coming mostly from bioethics, where bioethic scholars were saying, well, there is a vulnerable group. In particular, I don't know, prisoners are vulnerable when you do research, or special patients. So that was the particularistic view. The problem of the particularistic view is that you label those people. So if I say in this room there are 4 vulnerable people, and I start pointing at you, of course I am creating what they call a pathogenic vulnerability. So I am even exacerbating the vulnerability. But then there were wonderful gender scholars who were suggesting to shift from particular to universal and looking at inherent vulnerability of humanity. The legal scholar who did it like first, following from a big tradition of gender scholars, was Martha Feynman. And she basically said, humans are inherently vulnerable because we depend on others, we depend on society, we depend on structural complexity. We cannot survive alone. And this theory, this idea, of course, has some problems if we just consider it alone. The problem is that how you operationalize it. Well, it's very hard. If we are all vulnerable, why we need special protections, right? So this tension between, everyone is vulnerable and few people with the label on their head are vulnerable, this was a bit the tension behind, I think, the work. And of course, there might be a solution which is layered vulnerability, which is, okay, we consider inherent situations, but contexts matter a lot. And so context, I think, maybe one of the few things that I can say with, like some forms of certainty is that vulnerability is always contextual. So I think there's not such a thing as vulnerability per se. But you might say, well, bioethicists consider that. Yes, but because they were looking at a special context, which is research or bioethics or doctor-patient relationship. Or you might say, well, consumer vulnerability, think about groups. Yes, but there's a context, it's the supplier-consumer relationship. You might say, children are always vulnerable. Well, if we consider, children are vulnerable because their need for satisfaction, for human flourishing, for fundamental rights exercise, needs some enabler like adult society. But it's just a form of like universal vulnerability that is multiplied by their condition. So this is a bit the idea behind all that. And as we were saying at the panel 2 days ago, there was this panel on vulnerability with wonderful women at the table. We were all discussing the point on should we have a general provision about vulnerability, or should we just say, well, there are special conditions, special cases, let's consider them one by one, and I think, as we will see, data protection can help for that. So, but before data protection, I wanted to show this. So just why it's context. I said it's very much contextual, right? And why there is this context discussion here. Because actually, all the situations that we can analyze where there is vulnerability are based on power imbalance. And that's the thing I was trying to convey before, that power is such an important component in this discussion. So power imbalance creates vulnerability in every situation, right? Why? Because if we start from the point that vulnerability is based on human dependency, then what is power? Power is the possibility to exploit my dependency towards some needs. So in this circle, actually, vulnerability is really seen as the link from power to dependency, to needs, to possibility to harm. Let's make one example, 2 examples maybe. Me and Instagram. I might be on, okay, yeah, I will. I might be like on Instagram, I am on Instagram. I have a dependency from a sociality need, right? This dependency, why Facebook is powerful, why Facebook matters, what's the relationship between my fundamental right to sociality and Facebook as a platform? And here, maybe competition law can help. It's their exclusivity in my satisfaction of sociality that creates this power imbalance. So Facebook maybe is one of the 2 or 3 things that can help me to satisfy my need for human flourishing on social networks. So that was a bit the idea, but there will be time to discuss this. I will just choose slides about data protection because the book is vulnerability and data protection. I want to focus on the last 3 words very rapidly. There are at least, I think, 3 factors of data subjects vulnerability. If we consider that is contextual, so of course characteristics are important. Being a gay person qualifies me as vulnerable, okay, in certain situations. Of course, personal characteristics matter. Being black, having cognitive vulnerabilities inherent to my mind matters. But what is important is an encounter with the power of the potentialities of data controller. It's the encounter between me and the data controller that creates vulnerability. And then I was thinking, yeah, but something is missing in this discussion. And so I was thinking at vulnerability drivers. Why I was considering vulnerability drivers was mostly considering dark patterns because they are the keywords of this decade. And Paul De Hert was saying, well, but I don't buy it. I don't like this vulnerability driver discussion. It's a bit abstract. It's a bit difficult to distinguish between characteristics and potentiality. They're already there. And actually the editor, like the person who was reviewing the manuscript also had the same thing. So this vulnerability driver became, for me, an opportunity to rethink of the point. And so we can say the vulnerability drivers actually are a socio-political or malicious mechanism that is a multiplier of the power imbalance encounter between data subject and data controller. Being in an homophobic society is a multiplier of the risk to my fundamental right to non-discrimination, as I am a gig worker for Deliveroo and I want to share data on my location data if I go to a gay quarter in Brussels. So this is a bit, so vulnerability drivers is not just malicious acts, but it's also the context, right? If I am in a misogynist society, of course, the encounter between my characteristic and the power of the counterparty matters a lot. This is the last slide, second last, but this is the final concept I wanted to give about data protection. I think there are at least 2 different ways that vulnerability can analyze under data protection. One is being vulnerable during the data processing. Vulnerability to give consent, vulnerability to exercise data protection rights, vulnerability to understand my data protection, the risks of data protection. And this is not just a cognitive stuff, it's also power dynamics. An employee is vulnerable to give or to deny consent to the employer. And we can make many examples about consent fallacies and how vulnerability can be a concept for that. But the other problem is effect-based vulnerability. So vulnerability as a consequence of data processing. You process my data and then you manipulate my mind as a consumer. You process my data and then you discriminate me as a transsexual person, you know? So it's and they are not the same thing. They are both related to power asymmetries, but they're not the same thing. And so just to give a definition, maybe we can say the vulnerability matters when up to and then closing, to a certain level, there is a higher risk to my fundamental rights. So the DPIA really matters here, and that was the starting point. The GDPR was mentioning vulnerability in the DPIA, saying high severity and likelihood of impact of fundamental rights might be where the state, the law, the regulator should act with additional protections. And it's not just children. Okay, sorry, this was too long.
No, it wasn't. Thank you, Gianclaudio. Now, as I like the CPDP audience, will my book return? Because it's the only one.
It doesn't come to us yet.
Oh, lovely. Take your time. The movement should be towards ownership, which it's a sponsor. Anyway, no. Thank you. Now there's a panel, and the panel has listened carefully, and I thank you because you vitalized again that work of yours, which is layered and rich. So, but the arrangement with the panel was that we do a first round, more intuitive. What does this work do with you? How do you relate to it from your own position? And the order was fixed in the mails, so I start with Wojciech. And the idea is 7 or 10 minutes each.
Okay, thank you very much. I think I will speak also without the microphone if it's possible.
It's recorded.
Ah, it's recorded. Okay, so. Okay, so first of all, I have to start with disclaimer. Usually, the people from the institutions make a disclaimers, but my disclaimer is a little bit upside down because usually we hear disclaimer that everything what I say is not my own opinion, not the opinion of the institution. I'm in this wonderful situation that EDPS is one person body, which means that everything which is my opinion is an opinion of EDPS. Yeah. If it differs, I will say precisely what problems do we have to understand it, even inside EDPS as an institution. The second disclaimer would be that, of course, everything what I will say will be a kind of simplification, but that's obvious. We don't have enough time to discuss all the questions. What does it mean for me as the Data Protection Authority, and what the book means for me as Data Protection Authority? And at the same time, can we start with some assumption that General Data Protection Regulation is ready for the problem of vulnerability or is not? And my answer to the second question would be yes and no. Yes, meaning it creates a solid basis to discussion, but it does not solve the problems that are set here. And moreover, that makes the book important, because it's quite obvious that the data protection authorities meet in their work the problem of vulnerability and the problem how to address this individual one and this particularism, what was called here, and universalism. And let me start with a small anecdote. That's true that the word vulnerability appears in the strategy of EDPS for this mandate, and that was also why we were asked to take part in the first seminar on that organized here in Brussels some months ago. But I have to admit that when I used it in the strategy of my own institution for the term that I'm spending there, I used it as a buzzword. Well, of course, I wanted to use this word, but that was the moment when I was asked to come to the conference and to say what does it mean for EDPS, when I started to analyze myself what I actually meant. What the Data Protection Authority shall say about dealing with vulnerability. And that's one of the points where the book helps me. You probably are aware of the discussion that was in the end of 90s and the beginning of 2000s about the difference between the privacy and data protection as the concepts. And the idea of, or rather the explanation of Stefano Rodota, that privacy is subjective, multi-layer, individual, and contextual, and data protection is kind of objectivization of what is normally subjective. So trying to find the common denominator, not necessarily average one, common denominator from the perspective of data, not from the perspective of privacy. But of course, everybody says that we are not protecting the data, we are protecting the human being. But after all, the Convention 108, then the directive, and then today the GDPR rather says about sensitive or specially protected data than about the different special situations in which the people are, or the special contexts their privacy shall be dealt with. So in this sense, the GDPR is following the old concept of average approach to the problem. What you said also in your book in the first drafts of the GDPR and the first drafts of the communications that were before GDPR, the idea of average consumer and average data subject was even more present than in the final outcome. And anyway, it led to the situation in which the data protection authorities have to decide if they are explaining the data protection on the average level or the general level, or we have to take all the case and all the approach to all kinds of vulnerabilities that we see. And here, the concept which you study in the further part of the book about the sources of vulnerability and the fact that it is either permanent or accidental thing for the person is helpful, because it says to us that we as data protection authorities are not necessarily for discussing about the sources of vulnerabilities, but definitely we are the ones to discuss, or at least not to fight with the sources, but to decide what to do if the general state of vulnerability exists, or these accidental situations in which the persons are vulnerable may appear. And that is important in the three different parts of the work that we have. The work with complaints, where we have to do the particular approach to the subject. Guidelines, on the other hand, when we rather take the general approach. And it all leads me to the final point where the GDPR is not ready for the discussion about vulnerability. And these are 2 points. The one of them is the problem with one of the main principles of the GDPR. The second is a kind of paradox that we find here. The problem with the principles is about Article 5.1, which says about lawfulness, fairness, and transparency. And while lawfulness we are letting aside, while transparency is about something different, in all the works about vulnerability, I read about fairness. I actually read about fairness everywhere when we try to talk about data protection. And I have one homework for all of you, especially those who are not native English speakers. First of all, try to remind yourself what in your language, what word in your language is used in Article 5.1 for fairness. And even if you found that, try to compare it with the concept of fairness in English language, and try to compare it between the languages in Europe. We do not have the concept of fairness in Europe. We have the English-speaking discussion on that, and our national languages, our native languages, discussions as well. The Czech expression and the Slovak expression are completely different, despite the fact that these languages are not that different one from another. So we don't know what is fairness, and we try to say that the vulnerability can be approached with it. The second problem is that to fight with the vulnerabilities, we have to collect the sensitive data. We have to collect the specially protected data. And the more we want to fight with biases, the more data we have to collect. And that sets the DPAs in the very, very difficult situation. Because on one hand, we should promote not to collect the sensitive data, and at the same time, to fight with the bias on vulnerabilities, we will need this data. And this is not a new problem. This is the problem that exists throughout the whole history of data protection. But it appears time after time in the new acts that we are dealing with. In the AI Act, this is now the discussion which kind of sensitive data you can collect in order to check the bias in the AI systems. And this is not a problem for me, that the sensitive data is collected for this very purpose. The problem is that we are making the people used to the fact that they are asked about sensitive data. Because right now, having it as almost mandatory test, it means that each and every artificial intelligence solution will ask the people about sensitive data, not only about race, also about the other topics, in order to make this bias test. And that is dangerous to the idea of sensitive data and one of the basic ideas of the data protection. So thank you, Gianclaudio, for going through all these concepts that we have to take into consideration, because it builds a base which shall be known for each of the data protection authorities in order to work on that and in order to find out what does it mean for them to work for vulnerable persons.
Thank you. Julie, you want to follow up?
Sure. So thank you for inviting me to take part in this panel, and thank you for writing the book. There are two things in this book that I like a lot that I want to point to. One is just it's really good legal philosophy, right? And it's a very skillful use of the idea of layers of vulnerability to explain all of the different ways that that people come to data processing and data collection and data protection contexts and have their particular collections of vulnerabilities amplified and exploited. So that's really great. And it's really good legal analysis, right? So the really painstaking unpacking of all the different places in the GDPR where and interpretation where vulnerability is making inroads, right? Not just about children or not just about this group or that group, but the concept is forcing people to recognize it. And you have mapped that spectacularly well. And that's important because legal change doesn't actually happen all at once. It kind of creeps into the texts and to the interpretations, and then all of a sudden it is the thing you've been talking about all along, and so this is great. But then I have a couple reservations. So it seems to me that if we take seriously the idea of vulnerability as a root construct for data protection law, there are two choices. One, which I tend to suspect is the one we will choose but should not choose, is the idea is to sort of convince ourselves that that if we could just sort of respond to this more multifaceted, layered conception of vulnerability and correct for it, it would all be okay, right? So we figure out what fairness means. We require all the controllers and the processes to adhere to it. And we have done nothing really to address an underlying infrastructural, architectural state of commercially optimized data architecture and data infrastructure that does not give a hoot about our vulnerabilities or anything except surplus extraction. And focusing on vulnerability even in this tremendously rich and layered way that you have given us isn't going to dislodge that. So then the second thing that could happen once we focus on vulnerability in this tremendously rich and layered way that you've given us is we could really realize that this entire edifice of data protection law is not going to address that underlying problem, right? That's something I think is a very much needed corrective to many of the conversations around data protection that have been happening here. So if you were to have that slide again with the circle, right? Power creates vulnerability and so on and so forth. Power creates right now, again, a distributed, disaggregated, commercially optimized sensing and data harvesting infrastructure and uses it to create lots of kinds of vulnerabilities and an overarching, I don't want to even use the word, right, but a vulnerability because I think it's too much confusion, right, an overarching condition of precarity in which we are all just resources, and then naturally it is the current condition of our times that will the impacts of that will fall on different people in different ways for all of the reasons that there is unfairness in our world. But power doesn't care. This kind of power doesn't care about your race or your gender or your disability. It just cares about harvesting and selling ads, right? And creating a lot of extra cash and sticking it in a bank account in the Cayman Islands, as far as I can tell. And unless there's a way, right, to make this conception of vulnerability speak to that kind of power, then I worry that this lovely, lovely book that is so brilliant in terms of its approach to legal philosophy and its synthetic kind of drawing on consumer law and data protection law and its mapping of the inroads of change in the text of the GDPR. I worry that it sort of leads us to create a really beautiful catalog of vulnerabilities, and that's where we end. And that's not, I don't think that gets us all of the places that we need to be going. So, but it's such a good book, right? So it's really, really well done. Congratulations to you for producing it. And that's all I have.
Natali, please go on. I see Gianclaudio going really pale, and let's continue.
Right, not bad.
No, but I think it's great because, I mean, this is the start of a conversation, right? So you're pitching the topic out there and look at us. I mean, we're already in the middle of how to transpose that, and more of these discussions will follow. So Paul asked us in preparation of this panel, what does this book do to you? Which is a nice emotional question. And I would like to answer from two perspectives. First of all, as an academic and a colleague, I'm super excited and very happy for you. And I think you did not only write a book, but create a whole movement, this VULNERA Observatory, which is really cool. So if everybody who's interested should talk to you to whether they can join. And then as a consumer, because I'm an academic consumer, right? And as a consumer, I actually feel relieved. Over the past 10 years or so, we consumer and data users have been profiled and data analyzed and A/B tested and molded in all kinds of profiles and apps and by the advertising industry and Google, Meta, Amazon, and soon also OpenAI and co, all hold dozens, if not thousands of data points on us and know exactly our individual persuasion profiles. And yet, before the law, until now, we were all the average consumer. And as such, the hero figures of European consumer law. So decades of consumer information and European propaganda told us that to be strong, to be reasonably well-informed, observant, and circumspect. And not only that, but actually the safety, fairness, goodness of all the information markets, they were actually on our shoulders because our choices would actually give these signals to companies to do good or stop producing hostile services. So I think as a consumer, what does the book has to mean? I feel seen and kind of relieved. So vulnerability is not only any longer something that is reserved for the underdogs of the digital economies, like the elderly, the kids, and the lunatics. It's okay to feel vulnerable and be in good company of all of us, essentially, right? As you say, all individuals are vulnerable. And I think your anatomy of vulnerability, as Julie also already pointed out, is an excellent effort to show that this is not a debate limited to consumer law, but also matters for data protection law. And that brings me to my other hat, the consumer law expert. So as you know, I'm coming to that from a consumer law perspective. And in a recent project for VULNERA, the European Consumer Organization, together with Marijn Sachs, Hans Miklitz, and Joanna Strichaerts, we also reconceptualized vulnerability and thought about consumer law, the consumer law concept, and actually arrived at very complementary conclusions that in consumer law, vulnerability was in the law, but it was always this vague vantage points from which to assess some consumers' lack of their ability to activate their persuasion knowledge. But there was never really a serious follow-up. And with the Pew project, we tried to think this. And we argued that digital vulnerability describes a universal state of defenselessness and susceptibility to the exploitation of power imbalances that are the result of automation, data-fied consumer-seller relationship, and the very architecture of the digital marketplace, also the point you've been making. And then the question, what to do about this? And reading your book, I believe we actually should have a conversation and bring the data protection and consumer law perspective in conversation, and maybe also with you, actually. So, for example, I found it very interesting what you suggested, that an average, well-informed data subject does not exist. So there's actually some sort of professional duty or duty of care on the provider to consider vulnerability when designing their transparency notices, designing their services, and conducting this impact assessment. And I think Woody and Neil also talked about that in an earlier panel as some sort of sense of responsibility and loyalty towards the consumer, which is a very nice argument, kind of a romantic argument, actually. And the cynic in me wonders, why should a company try to mitigate our vulnerability if optimizing for exactly that vulnerability is actually the entire business model? And has maybe the law a role in creating such incentives? And maybe the answer could be in consumer law. So in the Unfair Commercial Practice Directive, in Article 5, it says a commercial practice shall be unfair if it's contrary to the requirements of professional diligence. Materially distorts consumer behavior, which is very nice, but the problem so far was always how to define professional diligence. And I think in your book, you make actually a convincing argument that it shall be a requirement of professional diligence to consider the vulnerability of the data subject. So maybe viewing data protection law from a vulnerability perspective is this much needed standard that we needed to give Article 5 more teeth. Second, and here I'm back as a consumer. As a consumer, I want more. I want justice. I want a statement of the law, some satisfaction, actually. So I wonder, should the exploitation of consumer vulnerability actually be at all a legitimate design goal that systems are optimized for? Should we not actually go this extra step and not only interpret fairness from a vulnerability perspective, but simply declare that exploiting our vulnerabilities as the result of tremendous power imbalances is unfair? And again, I think it would be really useful to see how we could integrate data protection and consumer law here. In consumer law, we have this concept of aggressive practices, which is defined by the exercise of undue influence due to imbalance of power. So we could go two ways. Either maybe we need a similar provision in data protection law, something like aggressive data practices that abuse and imbalance in data power and thus are simply unfair. Or we should go the way of the Unfair Commercial Practice Directive, and that's what we suggested also in the Buke project, to add to the blacklisted activities that are simply banished in the European market, one blacklist item, the use of psychographic profiles or other optimization-based approaches to exercise emotional pressure or psychological pressure with the aim of selling products or services is unfair. Basta. And finally, the third thing, a question more to you, and I think you also hinted already at that. If we are all vulnerable, some more or less, I wonder from what point on is vulnerability still a useful concept? And when do we need to move on and actually ask the next question, is there something like the average consumer? So maybe the logical next step from your analysis is to rethink the concept of the average consumer. And so maybe it's more adequate to say that the average user is a user who operates in an environment where digital businesses that we engage as are simply extremely well informed, observant of all our preferences and weaknesses, and very proficient in using that knowledge to optimize algorithmic systems for economic success. Thank you.
It's not my role as a moderator but these were three excellent interventions. I'm looking a little bit at my panel. Do you feel like just engaging in a dialogue with each other or helping out? Yes, should I do the second round and then we can... There was no Q&A in my mind because the mind was empty, so you can complain to the organizer. But I first give a second round because they have done such a tremendous effort and I'm so happy with this kind of knowledge transfer. So, Wojciech, you have a second round, a message or reflection?
Well, actually, my main reflections was already when I read the book that the difference in approach between the consumer law and the data protection law is actually much bigger than I expected and than I saw so far. So I could see that there were the differences which I neglected and which may probably somehow explain why it's so hard for the data protection authorities to work with the consumer protection organizations and consumer protection commissioners, if they exist in some country. For us, it's especially also the problem of discussion with our American colleagues, where the only approach to the so-called data protection is the consumer one. So that's the only one which is accepted, let's say. Yeah. So the FTC, Federal Trade Commission, is the data protection authority only in the meaning that they are dealing with the consumer law, and also the other regulators on the market, like the Fair Credit Scoring Bureau, for example, are approaching that from the consumer perspective. So that also allowed me, the book allowed me to at least match the whole matrix and to see the whole matrix in a more clear way. But I'm really happy to hear from my co-panelists their approach, because especially for those who are the specialists in consumer protection law.
Okay, when's the conversation? Julie or I think Julie.
Yeah, so I'm actually a fan of European consumer protection law. It's much better than US consumer law. But when you center the consumer, I think there are two things that you need to watch out for. Centering the idea of a consumer presumes that we are still talking about something that qualifies as a market. And it is not at all clear to me that that is correct. And that's actually kind of mind-blowingly weird. So I've started, when I try to write about platforms and data infrastructures, to not use the word market, because a platform is a kind of a structure for economic exchange that doesn't act like a market. It does not defer to interactions between supply and demand in at all the same way. It's almost impossible to take that word out of our language. It's so deeply embedded, and then you know come these proposals. You can't sell things in unfair ways, or there are certain ways you can't try to sell things. But underneath is a mechanism that I think is quite different. And so I worry about just kind of transplanting. The other thing that I think is a risk when you center the consumer is you center the thing that ad tech is supposed to be used for instead of the thing it is very often used for, which is kind of weaponizing it to push disinformation and conspiracies. And you don't, it doesn't work the same way, and it is not at all concerned again with you know getting you to buy a pair of shoes or whatever. And you don't even need personal data per se to do it. Right, you can use contextual advertising to put your vaccine conspiracy content next to your climate conspiracy content, next to your political conspiracy content, and you can use metadata about the content and about social networks to understand how to push that to places where it will get uptake, in the hope that you can make like 2 pieces of it trend and get media, television and radio uptake and convince some political figures, and then you're off to the races. And none of this is really aided by talking about consumers and consumer law or dark patterns. There's almost kind of an alien intelligence at work in the architecting of these again, I keep using this word a lot this year, but infrastructures to cause these perturbations that I think we could do worse than start thinking about it just explicitly in terms of climate. Just when you mess up the ocean or the atmosphere, you get this you get volatility, and you get ecological death in dead zones, and you get very uncontrollable, very toxic to human existence kinds of volatility. And it's not clear to me that we address that again when we center consumers, even though I absolutely love the Unfair Commercial Practices Directive. So I think something different has to be devised to kind of come to grips with what these systems are and how they work.
I think I would like to print a sticker. I love the Unfair Commercial Practice Directive.
I do. I love it. It's terrific. I wish we had one.
I think these are really sharp observations. I think we could have a long discussion. I really find it interesting that what you're saying, that we should consider if these are still markets. I think there's a counter argument to be made. Maybe what we're experiencing now is market logic in its perfection extreme, actually, to a situation which is maybe the end product of market competition, that there is a duopoly or triopoly of 3 very powerful organizations, which are the result of market logic. So I think that is an interesting discussion to be had. And maybe another one is to what extent the laws of markets as we developed them 200 years ago are still the right laws to define market activity. I also think, and also listening to you reinforced that the next myth we need to tackle, and the next book that needs to be written, is this idea of the consumer as a commercial being. And I think that is something that consumer law is weakening consumer law, because it still has this definition of a consumer as a purely commercial being, which is not our reality, right? Because in the digital markets, if we call them still markets, we negotiate constantly for things that are not simply products, but the way we communicate with each other, inform each other, work, function online, everything. And I think a beautiful area to illustrate that point is political microtargeting, which is very much not about the market, it's about politics, democracy, everything that is close to us as a society, but which, at least online, has completely succumbed to market logics, right? The data is the same as for advertising, the actors are the same, the tools were lent from commercial attack. So there's this mixing up of us as political and commercial beings. And this is something that consumer law is grappling with to draw the boundaries. Originally, I had also prepared, because I know we talked about this earlier, this idea of targeting the underlying causes that brought us into the situation. And I think we both agree on this point that this is important. And actually, I would like to make a plea, defend European law here, because the European legislator has been extremely active in addressing various aspects of vulnerability all across the legal framework, the DSA, the DMA, the political migratory regulation, and the AI Act. So if we have some time, I'm very happy to explain some ways how the regulator tries to actually take this concept of vulnerability further and addresses it, which leaves us with a really interesting mix of proposals, probably completely inconsistent right now, and for a follow-up of the BEER project, we actually mapped these. I'm not sure how deep I should go into this, but if you ask, I'm happy to.
Yeah.
So if I can add one sentence, since the European Data Protection Supervisor is the supervisor of the public sphere, the public institutions, I actually find more problems to import the notions from the consumer law that are directed to the market, to the activities which are absolutely not connected with the market. You said about political advertising. I will say that one of the first places where we started to use the vulnerability concept was the external borders of the European Union. Yeah? So the migrant law, and this is not market at all. And if you look at the three examples which are going throughout the whole book, that's the problem of race, health, and asylum. And asylum is definitely not the market-based. Health mainly is not the market-based, and race appears everywhere. So the importing the solutions from the consumer law is important for the data protection law, but it should not blur the subject of vulnerability, because that is not only the market-oriented notion.
Yes. 2 minutes. 2 minutes from the audience. Go.
Yeah, this shouldn't be like a second PhD defense, but but I really love this. No, I mean, yeah, this is like the notes for first chapter of next book. So just to say, I think two reflections, like very rapidly, that I'm getting. I think you all are drawing a line that I can summarize in two maybe main points, and is how, so what do we do with this vulnerability to make it work, like solutions, etc.? Should we zoom more and keep this subjective perception, or de-zoom? And I think that Julie's point on if we consider power and vulnerability as a subjective problem, this is this neoliberal approach that also discrimination law can have, to say vulnerable, the problem is solved, and we don't look at the bigger power infrastructure problem. So that's why my next research point is looking at the bigger picture, de-zooming a lot, and also going beyond this idea that you can fix everything with the technocratization and with, accountability, and no, there is something higher to be considered, and this something higher goes with the call that Natali was making. Let's connect consumer protection, data protection, and I would add competition law to look for a general theory of power imbalances and how the state should look at that. Because if we keep the subjective approach that I understand, it's part of the book, but because the book is mostly descriptive in its parts, and then the more speculative parts need to come. I think that if we look just at the subjective perspective, as Natali was saying, we are all vulnerable, and if we are all vulnerable, what do we get? So the point is also how to measure impacts on fundamental rights, because if we can make a distinction between measuring the impact, we can understand what are the groups that the state should consider for rebalancing. So just that, but I really needed to emphasize these points. Yeah.
Okay, we take a couple of questions. We have 5 minutes more. Please go ahead.
Yes, thank you. It's more of a comment just to pick up on what Gianclaudio said. I think I want it to be heard as well because we are working on this together sometimes and throw ideas out. One of the big benefits of using vulnerability can be to use the concept to map risks. Right, and we have a DSA that is risk-based, we have GDPR that is risk-based, we have AI Act coming up that is risk-based, and also not just risk, but also in consumer protection law, we have likelihood of certain transactional decisions, and you can map the likelihood depending on how deep the vulnerability is. You can really use this layered concept and complicated and nuanced concept of vulnerability to see different levels, degrees, depth of vulnerability. And some things come out when you measure it, and I have done it, Gianclaudio. When you look at the concept of vulnerability and you analyze ad tech, for example, you see that the depth of vulnerability is unacceptable. It's beyond unacceptable, and it makes it very clear that it's not just we feel vulnerable. It's we are so deeply vulnerable against that it's unacceptable with the ideas such as human dignity in mind and et cetera, et cetera. But also wanted one counter argument to Julie's point about consumer and the infrastructure and making. This is maybe a very weak counter argument. Just the point is that if we conceptualize the issue as the consumer issue, it can help to remind people that there is money in question. So many people, when we are behaving with platforms, we forget that we are in the commercial relationship. And I think that part of dealing with it as a consumer situation helps us to remind that it's about money. And just a thought that why it can be helpful. Yeah. Thank you.
Another remark, comment, and then we come back. I have not read
The
Please use the microphone.
I have not read your book, but I will just throw some insights from your presentation. So from the many rationales that data protection has, I think you take that asymmetry of power as a yardstick then to deploy all your argumentation and theory, right? I think the European legislator tried to measure that benchmark through a data point of view, as Wojciech was saying, right? And he deployed a formal framework based on data and on categories. And we can see that, for instance, in the standard data regime and the sensitive data regime, that I think they have some value because they provide a lot of legal certainty for private operators that are processing data. And then you have other consequences, for instance, DPIAs that also contemplate other aspects but have that data component and categorization in themselves. Now, I think you are trying to measure now or give back to the data subjects a new theory where vulnerability as something that concerns the individual is being assessed. And you are taking a human subject and trying to deconstruct it in different aspects to measure that vulnerability. And on all those aspects, you are trying to give a depth to assess that vulnerability. So my question would be, if you take that theory to base data protection on, how can you make that concept into something workable that can provide legal certainty? How can you encompass all those deconstructions and make them into categories? And how can you measure in depth those triggering or threshold points to then assess impacts? That is sort of like my general comment. Perhaps you are describing that in the book, but I didn't have the opportunity to read it.
Right. Before you answer, we take the last question, if you excuse me, audience. This is the last question.
So just last question. Congratulations again for the book. And it struck me yesterday and today, especially when we're talking about vulnerabilities, we are ending in this almost like a technocratic nightmare of like layers, assessment, risks. And when you go back to founding mothers of vulnerability study, especially in Feynman, this is not about theory of understanding vulnerability, it's responding to vulnerability. Her response was a political response in the terms of the welfare state. I know you touch upon this a little bit in the last 2 minutes when you were talking about active state, but what does it mean for you in the sense that it's not only regulation, of course, and I'm not sure that data protection is the only, probably it's not even the start for those responses, but do you have any kind of directions you want to go with your work in that sense?
Floor is yours.
20 seconds, I guess. The two questions are related very much. The three questions, but I have two very conflicting points, right? The first is how to operationalize in practice, and the second is how to solve as an overarching problem. If we could answer this, data protection would be done, and we could change CPDP to other topics. But no, I just wanted to say I think there is these two chances to consider. How to make use of the concept, we have to understand what is a risk to fundamental rights. It seems stupid, but it's there. We don't know how to measure risk. Once we know, because we can know cybersecurity risks, it's maths. We can know how, and thanks to the work of Alessandro on impact assessment, there are ways to assess the impact, but once we know better, we can make a group of high risk without forgetting that the state should act, paying for data subject representations in an impact assessment, perhaps, and many more things. Thank you so much. So happy and honored. Thank you.
You okay? Hit you on the back.